Are you considering starting a business with other humans? If so, you're going to want to hear about the most common issues to corporate regulations and bylaws and LLC operating agreements among multi-owner businesses. And we're going to cover that today in part 4 of my series, Making Your Business Legal. So if you own your business yourself, if it's a solely owned LLC or corporation, then you don't really have to worry about your operating agreement too much or your bylaws and regulations too much. And the reason why is because you are the king or queen of your own business and you're in 100% control. At that point, the reason you need them is just to make sure that you avoid any personal liability and you maintain your corporate formalities, which we're going to talk about in the next episode. But when you have business partners, you actually use this document as the sort of the constitution for your company. It's going to resolve disputes. It's going to tell your company how it should act whenever there are certain formalities or anything that's covered in the agreement. It will address exactly how those things should go. So for those of you who are new to being in business with other people, I wanted to touch base on just a few of the biggest points, the top 7 issues that I see in regulations and bylaws for corporations and operating agreements for LLCs when there are multiple owners. Number 1, equity. What percentage of equity does each person have? How do they get their equity? Is it through money they're putting in now? Is it through money they're putting in now and promising later as well? Is it through sweat equity from operating the business? Are there opportunities for the equity to change? This adds a lot of layers of complexity, but you can make it however you want to make it. It's an agreement. You can add terms in, change it, make it super customizable. But you need to make sure that you address exactly who owns the equity and how that works. Number 2, officers and salaries. So it is common in all of these agreements to mention the officers. You just say this person is the president of the company, this person's the treasurer, and this person's the vice president and secretary, right? Those are corporate formalities. So, they're in there. But what you really need, and what I suggest, especially just in the interest of communication, is to go ahead and state what the plan is for salary for these officers. Because if some of the owners are expecting one thing in terms of a salary, and the officers and the person who's getting paid, who's in charge of actually paying themselves through payroll, if they're expecting something else, that could cause friction. So you're working together, you need to be transparent, and salary is one thing to consider putting in the agreement. Just to be clear, I'm not saying to lock in a salary. I'm saying to talk about how you even determine salary. What's a reasonable range? What is the frequency of the review of salary for higher pay? I see it all the time. You got a minority owner who's a sweat equity owner who is getting ready to quit because they're not getting paid enough money. So just consider that in advance. If you've got somebody who's running it for you on sweat equity, how is their salary handled and how has that changed? Number 3, voting. So there are procedural issues that you can deal with when it comes to voting in terms of, I always make sure to put in agreements that you can vote by email. You don't have to do registered certified mail. Some people want to make it harder to be able to vote, and so they'll put those provisions in there. So there's sort of the process provisions for voting, but then there's the substance. Who gets to decide how much is each person's vote worth? What's typical is the amount of ownership is equal to the amount of your vote, but that's not always the case. You can have variable voting and ownership percentages in LLCs. So the other issue with voting to think about is what sort of decisions can be made by the officers, the president, or the manager if his manager managed, and what sort of decisions have to be voted on by the owners. So that's another thing that will go in this operating agreement for LLCs, regulation, or bylaws for corporations, depending on what state you're in. You can also require different voting percentage thresholds for different issues. For example, you may say that you can terminate a member for with a 75% affirmative vote, or you can admit a new member with a 75% vote, or it could be 60%, or it could be 43.2%. You probably actually want it to be a majority generally. But the point is, it can be anything you want it to be. Number 4, capital contributions. This is a big one. So if I'm an owner, when do I have to pay money in? And when am I expected to pay more in? Is it just a one-time payment obligation, or is it ongoing? Is there a vote that can trigger requiring me to pay more money in the future? What happens if I don't pay at that point? Are you going to sue me? Are you going to come after me for the money? Or do I just lose my, do I just lose some of my interest in the company? I recommend the latter. You don't want to be suing your business partners all the time. Make sure that you have thought in advance about the issue of what happens when the company votes for everyone to contribute more money, and then some of the owners don't. What's going to happen to those owners and their ownership interest? Number 5, distributions. Okay, so number 4 is contributions, money going into the business. Number 5 is distributions, money coming back to the owners. Dividends in corporations is what this is called. It's profits, okay? So how are these handled? Is it just on a whim of the majority? That's not a great way to do it. How do you decide how much to distribute? You know, you can put formulas in the agreements. So, you know, what's typical is it's quarterly, and there's an operating budget that's determined, and whatever is, money is in the bank that exceeds the operating budget can be distributed out or issued as dividends. But every company handles it differently. You just need to make sure that you're all on the same page with your other owners and business partners. Number 6, member withdrawal, death, or termination. So it's kind of a lot of things grouped into one, but it's basically what happens when somebody wants to leave, or you want someone to leave, or they die, right? And so this is typically addressed in the agreements. Some of the things that are not super consistent, and I've seen all sorts of terms for, are reasons to terminate. So, the reason you want to terminate somebody is you don't want them as part of your business anymore. Just to be clear, when they're an owner, it doesn't mean that they're obliged to be part of the day-to-day business necessarily, okay? Like, you can have silent partners and silent owners. But at any rate, if you just really want to get somebody out of ownership, there may be good reasons that you would want to do that. You have to figure out how are you going to handle that process. So one thing that I've seen that's common is you can only kick people out if there is fraud, or if they've some intentional tort against other owners or against customers or whatever. But think about what the standard is for kicking someone out, and then so they would have had to have committed some sort of act, and then also what is the percentage vote required to go ahead and terminate that member. And with any of these issues, termination, withdrawal, death, the big question is, other than is it happening, has it happened, can you do it? The big question is, how much does that person or their estate get paid for their interest? Because their interest goes back to the company, which that means now there's more money to be divvied out between the other owners, or they may even divvy out your ownership interest itself. But the question is, how much are you going to be paying anybody who's leaving? What is typical I've seen is some sort of formula that then has a promissory note where it's paid over time, which makes it easier to do for the company. That's what I tend to recommend, but like everything else, there are many ways to customize it exactly how you want it. Number 7, non-compete agreements. So these are not in all of these LLC operating agreements, corporate regulations and bylaws. They are in some. And so typically what you would do is prevent other owners who have inside information of the business in particular, officers in particular, from going and competing in the same line of business while they're still owners, or for a period of time after they are no longer owners of the business as well. Again, not in every agreement, but it is something to think about because it might make sense for you and your business. So those are the 7 biggest multi-owner issues that I see in corporate regulations and bylaws and LLC operating agreements. Next time we will talk about avoiding having your corporate veil pierced. Nobody wants that to happen. And exactly what you need to do to maintain those corporate formalities so that that does not happen to you You don't want to have personal liability. That's why you got an LLC or corporation in the first place. We'll talk about that next time. See you next time. Bye-bye.